we'll talk about freedom of assembly, that is there in Article 19, Clause 1, Subclause B, and restriction in Article 19, Clause 3. It guarantees to all citizens of India to assemble peaceably and without arms. The right of assembly includes the right to hold meetings and to take out processions. This right is, however, subject to the following restriction. First thing, the assembly must be peaceable. Second thing, it must be unarmed. Third thing, a reasonable restriction can be imposed under clause 3 of Article 19. Right to assembly is implied in the very idea of the democratic government. The right of assembly thus include right to hold meetings and take out processions. This right, like other individual right, is also not absolute, but it's a restrictive. The assembly must be non-violent and must not cause any breach of public peace. If the assembly is disorderly or riotous, it is not protected under Article 19, Clause 1, Subclause B, and reasonable restriction may be imposed under Clause 3 of Article 19 in the interest of sovereignty and integrity or public order of India. Now the question is, when a lawful assembly becomes unlawful? That is the most important questions. Anyone, if you have any idea? Basically, there are certain criteria. It is given in IPC section 141. However, it is going to change, so you don't need to remember this particular section of IPC. But I'll tell you the ground. First, to resist the execution of any law or legal process. तो अगर कोई legal process है, कोई order है, उसका execution होना है और उसको आप resist करते हो, then वो assembly unlawful हो जाएगी. दूसरा क्या है कि कमिट एनी मिसचीफ और क्रिमिनल ट्रेसपास. आप किसी भी घर में घुस गए, कहीं भी किसी बिल्डिंग में अनऑथोराइजली घुस गए, देन इट इज़ कॉल्ड क्रिमिनल ट्रेसपास. ठीक है, एंड देन दिस असेंबली विल बिकम अनलॉफुल. अब किसी की प्रॉपर्टी में घुस गए आप एंड उसको फोर्सफुली आपने टेक ओवर कर लिया, देन ऑल्सो दिस असेंबली वुड बिकम अनलॉफुल. And if it compel a person to do what is not legally bound to do or omit which he is legally entitled to do. अब जैसे मान लो कि कोई एक भीड़ है, भीड़ ने एक पुलिस वाले को कैप्चर कर लिया, पुलिस वाले को अपनी कोई लीगल ड्यूटी करने जाना था. ठीक है, तो फिर इस असेंबली को हम लोग अनलॉफुल असेंबली बोलेंगे. दूसरा क्या है कि कोई पर्सन है, ठीक है, और उसको कह दिया कि जाके थेफ्ट इस कोई चोरी करके लेके आओ या किसी चीज़ को लूट लो. ठीक है, तो इट्स नॉट अ लीगल थिंग, लेकिन आप उसे कंपेल कर रहे हो और आपने उसकी हो सकता है साथियों को कैप्चर कर रखा हो, तो फिर ये अनलॉफुल असेंबली हो जाएगी. और by means of criminal force or show of criminal force to overawe the government or any public servant in the exercise of his lawful powers. तो अगर आप कोई भी असेंबली ऐसा करती है तो ये अनलॉफुल असेंबली बन सकती है. ठीक है, So initially the assembly cannot be unlawful, but when assembled may be subsequently become unlawful if it becomes violent or it likely to result in disturbance. तो ये आर्टिकल फ्रीडम ऑफ असेंबली है. नाउ विल टॉक अबाउट, हाँ थोड़ा सा आई जस्ट टॉक अबाउट इन द अमेरिकन कॉन्टेक्स्ट. सो अमेरिका के कॉन्टेक्स्ट में क्या है, अमेरिकन कॉन्स्टिट्यूशन इट गारंटीज टू द पीपल टू राइट टू कीप एंड वियर arms. But the Indian Constitution does not guarantee any general right to carry arms to any assembly. And we have a Arms Act that prohibits possession and carrying of unlicensed offense weapons. Carrying weapons that is likely to promote carrying weapon, and we also have this preventive of seditious meeting act 1911, which prohibit public meeting that is likely to promote sedition or to cause a disturbance of public tranquility. So we have these kind of things. And now I'll talk about Article 19, Clause 1, Subclause C. What is this? This is freedom to form association. And the restriction imposed in Article 19, Clause 4. Article 19(1)(c) of the Constitution, it guarantees to all Indian citizens the right to form association or union. So it can form association or unions or cooperatives. If the question is coming that forming cooperative society is a fundamental right, yes it is. Forming union is a fundamental right, yes it is. Forming association is a fundamental right, yes it is. Under clause 4 of article 19, however, the state may by law, remember this thing, the state will have to bring the law. So by law, either the law has to be brought or it can be existing law, impose reasonable restriction on this right in the interest of public order or morality or the sovereignty or in the integrity of India. The right of association, it presupposes organization. It is an organization or permanent relationship between its member in matters of common concern. It therefore includes the right to form companies, societies, partnership, trade union, and political parties. So, right to form a political parties also come under this article 19(1) clause C. Remember this thing. The right guarantees is not merely the right to form association but also continue with the association as such. अब ऐसा नहीं है कि आप ने सिर्फ एक कोई पार्टी फॉर्म कर ली या एक कंपनी फॉर्म कर ली या यूनियन फॉर्म कर ली, आपके पास राइट है उसके साथ एसोसिएट रहने का, ठीक है, अपना एसोसिएशन कंटिन्यू रखने का. द फ्रीडम टू फॉर्म एसोसिएशन इम्प्लाइज ऑल्सो द फ्रीडम टू फॉर्म और नॉट टू फॉर्म और ज्वाइन और नेट नॉट टू ज्वाइन एन एसोसिएशन और यूनियन. अब कोई एसोसिएशन या यूनियन है तो आपके पास राइट है इसको ज्वाइन करने का और ना ज्वाइन करने का. सिमिलरली आपके पास राइट है कोई भी एसोसिएशन को फॉर्म करने का और ना फॉर्म करने का. तो नो वन कैन कंपेल यू टू फॉर्म एन एसोसिएशन एंड नो वन कैन कंपेल यू नॉट टू फॉर्म एन एसोसिएशन. रिमेंबर दिस थिंग. The right to form an association necessarily implies that a person forming the association have also the right to continue to be associated with only those whom they voluntarily admit in the association. Any law by which members are introduced in the voluntarily association without any option being given to those who have voluntarily joined it will be a law violating the right to form an association. So these things you need to remember. Now I'll talk about the restriction part. That what are the restriction on this article? The right of association, like other individual freedoms, is not unrestricted. Clause 4 of Article 19 empowers the state to impose reasonable restriction on the freedom of association and union in the interest of public order. Second, morality. The other one is sovereignty of India. It shapes existing law insofar as they are not inconsistent with fundamental right of association. तो इसका मतलब ये हुआ कि जब जिस टाइम पे द कॉन्स्टिट्यूशन केम इनटू द एग्जिस्टेंस देयर यूज्ड टू बी सम लॉ. If these laws are not inconsistent with the fundamental right, then those law will be there. ठीक है. Anyone, if you have any doubt so far? One more thing.
सर
Yes.
सर मेरा नेट डिस्कनेक्ट हुआ था लास्ट कहा बताया आपने.
आवाज़ नहीं आ रही है आपकी. कुछ बोल रहे थे आप?
सर लास्ट आपने क्या बताया वो सुनाई नहीं दिया क्योंकि नेट डिस्कनेक्ट हो गया मेरा बीच में.
मैं आपको यही बता रहा था कि ये रेस्ट्रिक्शन इम्पोज करता है क्लॉज 4 आर्टिकल 19. रेस्ट्रिक्शन यही है पब्लिक ऑर्डर, मोरालिटी एंड सोवरेनिटी ऑफ इंडिया. सो दीज आर दी लिमिटेशन. इसके बाद में एक चीज़ है कि द राइट टू फॉर्म यूनियन डज नॉट कैरी विद इट द राइट टू अचीव एवरी ऑब्जेक्ट. The trade union have no guaranteed right to an effective bargaining or right to strike. So right to strike is not included, or right to declare lockout. These things are not included in this particular right. So they can form the association, they can have certain things, but certainly not right to strike and not right to declare lockout. These things are not covered under the purview of 19 clause 1 subclause C. We'll talk about freedom of movement now.
So one question.
Yes.
So if there are reasonable restrictions, so is the authority allowed to declare the association as unlawful in that case,
Yes, definitely.
or does it take away the right of the association, like they don't recognize them, or like
Anything can
always?
happen. First it will be declared unlawful, and thereafter the other things would happen. Say for example, there used to be this Jamiyat ul Taba, I forgot the name. It's a organization in Kashmir, and it has been banned basically by Home Ministry under section 3 of UAPA, right? So first they'll declare it unlawful, and thereafter it will be banned.
Okay.
PFI, I think they have banned PFI also, right?
Yes, Kerala, no?
Yes,
Sir.
yes. PFI also has been banned. So it was declared unlawful and thereafter it has been banned. Home Ministry banned it for 5 years on the reasons to over threats to security and it links with terror organizations. So I was discussing freedom of movement. Freedom of movement. It is guaranteed under Article 19, Clause 1, Subclause D.
Sir, screen is it not visible?
Wait. So I was writing and it was not visible, I think. Okay. Now it's visible.
Yes, sir.
Okay. So freedom of movement, it's there in the Article 19, Clause 1, Subclause D, and the restriction imposed in 19.5. It guarantees to all citizens to move freely throughout the territory of India. However, this right is also not absolute. It is subject to reasonable restriction that is mentioned in the clause 5 of Article 19. That's it. First thing is in the interest of general public. In the interest of general public. Second thing, that in the interest of any scheduled tribe. Article 19(1) Clause D of this Constitution guarantees to its citizens to go wherever they like in Indian territory without any kind of restriction whatsoever. They can move not merely from one state to another but also from one place to another within the same state. The freedom cannot be curtailed by any law except within the limit prescribed under Article 19 Clause 5. What the Constitution lays stress upon is that the entire territory is one unit so far citizens are concerned. So for every citizen, the entire territory is one unit, and the objective is to make Indian citizen national minded and not to be petty and parochial. If I have to talk about ground of restriction, then these ground of restriction are given in clause 5 of article 19. Let's discuss these. First one we have already discussed, and again I am telling you, in the interest of general public, and second is for the protection of the interest of scheduled tribes. So these are the two grounds. A law providing for externment of dangerous character from a particular locality cannot be called reasonable if it does not specifically define as to what is meant by dangerous character, as it gives the administrative authority arbitrary power to determine as to whether a citizen is of dangerous character. तो अब कोई किसी सिटीजन के बारे में बोल दिया कि भाई ये डेंजरस है, तो फिर बताना पड़ेगा, अदरवाइज इस टाइप की रेस्ट्रिक्शन मानी नहीं जाएगी. Now, there is one more contentious point, that whether the prostitutes have the right to move or not. So, there was this case in state of Uttar Pradesh versus Kaushalya case. So, in this case, the Supreme Court held that the right of movement of a prostitute may be restricted on ground of public health and in the interest of public morals. The right of a citizen to move freely may also be restricted for the protection of interest of scheduled tribe. The object is to protect the original tribe. which are mostly settled in, some are in Assam, some are in northeastern state, and in some other countries. So these tribe have their own culture, language, customs, and manners, and it was considered necessary to impose restriction upon the entry of outsider to these areas. It was feared that uncontrolled mixing of these tribes with the people of other areas might produce undesirable effect upon the tribal people. So this is the reason that these restrictions are there, so that you cannot freely move in the tribal area. The next one is freedom of residence. It's given in 19 clause 1 subclause E and article 19.5 imposes the restrictions. So according to this article, every citizen of India has the right to reside, first thing reside, and settle in any part of the territory of India. However, clause 5 of article 19, reasonable restriction may be imposed on this right by law in the interest of general public or for the protection of the interest of any scheduled tribe. The same restriction. The object of the clause is to remove internal barriers within India or any of its parts. The words territory of India used in this article indicate freedom to reside anywhere and in any part of the state of India. Now, it is to be noted that the right to reside and right to move freely throughout the country are complementary and often go together. Therefore, most of the cases considered under Article 19(1) Clause D are relevant to 19(1) Clause 1, 19 Clause 1 subclause E also. So 19(1) D and E mostly same. This right is subject to reasonable restrictions that are imposed by law in the interest of general public or for the protection of interest of any scheduled tribe. Here we need not to discuss much about the exception, because exception this we have already discussed. Now I'll discuss the last one and we are done for the day.
Sir,
Yes.
you mentioned about procedures limited to the movement, but in case of residents also, they are subject to a certain area only. No.
The problem is, see, they cannot be discriminated just because they are prostitute. Okay. The reason is simple: public health or in the interest of public morals. These are the two reasons or two
So
grounds.
they come under both the threads of movement as well as residence. That's
Yeah,
what I'm asking.
definitely they can come under the both.
Okay.
Freedom of profession, occupation, trade, or business. 19(1) G and 19 clause 6 puts restriction. This article guarantees that all citizens have the right to practice any profession or to carry on any occupation, trade, or business. However, this right to carry on a profession, trade, or business is not unqualified. It can be restricted and regulated by authority of law under clause 6 of article 19. and the state can make law imposing reasonable restriction on this right in the interest of public. Second, prescribing professional or technical qualification necessary for practicing any profession or carrying on any occupation, trade, or business. Third one is enabling the state to carry on any trade or business to the exclusion of citizen wholly or partly. These are the certain restrictions. Now, the trade and commerce through internet. The freedom of trade and commerce through the medium of internet is a right protected under Article 19, Clause 1, Subclause G of the Constitution and subject the provision that we have already discussed. So, if we talk about right to carry on the business, it also includes the right to close the business also. Now, I want to tell you that right to establish institution for imparting medical and technical education is a right, but not a fundamental right. This thing you need to remember. And they have that the ground was that education have has never been commerce in this country. So these were certain things that were against to establish an educational institution by these medical or technical education institution. So we know that no right is absolute. So right to close a business is also, I was telling you, right to close a business is a fundamental right, but it is also not an absolute right. It can be restricted, regulated, or controlled by a law in the interest of public. And therefore, if you want to shut down a company or if you want to bind up a company, then there is a very long procedure that you have to follow. Then only you can do it. Third thing I want to tell you that you have a right to carry profession, occupation, trade or business, but it should not be illegal in the character. अब ऐसा नहीं है कि आप लोग जो है बिना लाइसेंस के शराब बेचना चाहो या ड्रग की स्मगलिंग करना चाहो या फिर बाहर से लाके करेंसी लाके इंडिया में सब करो, तो ये सब चीज़ें जो इलीगल एक्टिविटीज़ है उनको ये राइट कवर नहीं करता है और आप वहाँ पे अपना फंडामेंटल राइट क्लेम नहीं कर सकते हो. तो बस यही इतनी सारी चीज़ें थी जो मुझे आपको बतानी थी. We are done with this right to freedom. Tomorrow we'll discuss Article 20, and if time allows